Hello, all the CA Foundation students. This is a high time for you to start with a quick revision of a 15 marks chapter, the Negotiable Instruments Act 1881. In this particular video, I'm trying to make a very quick revision of all the concepts of Negotiable Instrument Act in a lesser time possible, okay, which will be helping you to score the 15 marks in exam, okay. So without any ado, let us start with the concept. See there. What are all technically important from the exams? I am touching those areas and completing them. Okay. Now, okay, let's begin. So mainly some important concepts only I am covering, means what are required from exams point of view, not from classroom point of view. Classroom line I will explain, but here exams. For if it comes in exam, how to score that 15 marks. First one, in this particular act, Negotiable Instruments Act, we are going to cover three negotiable instruments: promissory note, bill of exchange, and a check. Okay, number one, it is applicable to whole of India. Okay, next, meaning of a negotiable instrument. Meaning of a negotiable instrument. So let's see. Negotiable means transferable. Instrument means a document. Okay. Okay. Next one. How it is transferable? It is transferable. It is transferable in three ways. Number one, from one person to another person, it is transferable either by mere delivery or endorsement and delivery. Mere delivery means what? Just by giving to some other person, he will become the owner. That's called as a mere delivery. Okay. Endorsement and delivery means signing, everything is procedure is required. Okay. Okay. Now, bearer instruments or an instruments are bearer instrument. Bearer instruments are delivered. Bearer instruments are negotiable by mere delivery. Bearer instruments are negotiable by mere delivery. Means what? Bearer instruments are those instruments which are transferable from one person to another person. The ownership will be transferred from one person to another person just by bearing it. If you hold it, you will become owner. It's like a cinema ticket. For example, I have a cinema ticket, I lost it, some other person took it, he become the owner. It's a bearer instrument. And the ownership is transferred by mere delivery. Understood? So no signing, nothing is required. Endorsement not required. So negotiable instruments are of two types: mere delivery negotiable instrument, endorsement and delivery negotiable instrument. Okay. Next, either to the order or to the bearer. That's why I said. Next, what is a negotiable instrument? NI Act does not give definition. This is only meaning. Okay. There are three types of negotiable instrument: pro note, bills of exchange, and a check. Very important. This is important question number one. Essentials of a negotiable instrument. First, listen carefully. There are 8 important essentials to a negotiable instrument. Essential number one. Negotiable instrument is transferable from one person to another person. Number one. Because negotiable instrument, negotiable, transferable. Like that you can remember. Next question. Transferable you said. How many times? Any number of times. Okay. How to transfer? Either by mere delivery. Okay. Next one. Negotiable instrument means, and I say instrument, it's a document. Therefore, it should be in writing. It must be signed. It must be signed. Next, it should contain some important things: amount payable, time of payment means a date you have to write, and pay. The person to whom you are paying must be there. To fake person, if you pay, that becomes a binary transaction. So, essentials like 8 essentials. 8 you should write in exam for 4 marks. Number one, negotiable instrument is transferable from one person to another person. Transferable any number of time. Transferable by mere delivery also. And it must be document. Therefore, it must be in writing and it must be signed. Next, three things must be certain: amount, time, and the recipient pay. Next, holder title is free from all defect. This only concept I will discuss at a later stage. Just remember, the holder title is free from all defects. Next, negotiable instruments either has unconditional order or unconditional undertaking. Okay, UC means unconditional. What is order? Bill of exchange is a order. Bill of exchange is a order. Check is an order. But in case of promissory note, there is a unconditional promise. That's called as unconditional undertaking. So bill of exchange and check is a order, and promissory note is an undertaking. With this, we completed the essential characteristics of negotiable instrument. Next, promissory note. Okay, I'm putting only 3 minutes time for promissory note. Okay, let's understand. Start. Time starts now. Okay, time starts now. So let's begin. I'm starting a timer. Listen, 3 minutes time. 1, 2, 3, start. Okay. What is a promissory note? Promissory note is an instrument in writing. So promissory note cannot be in oral form. It contains an unconditional undertaking, means a promise. Okay. And it should be signed by the maker. Maker is a debtor. To pay a certain sum, it should be a certain sum. Next one, money only. Kind cannot be there. To a certain person only. The recipient should be a certain person. Okay, or the order of certain person, either to me or you should tell to the order of Kaushik Mukesh. Means in the promissory note you should write, I will pay on the due date either to Kaushik Mukesh, or if Kaushik Mukesh orders me to pay to some other person, to that person I will pay. Okay, so what are the essential characteristics you need to understand as follows. Number one, it should be in writing. Oral promissory note not valid. Express promise must be there. Means just saying that I have to pay you 5,000, no promissory note. You should clearly tell an express promise to pay. The word promise is not important, but you must tell that yes, I am indebted to you for some amount of 5,000 and I will pay to you on a certain date. Like that you should tell. There should be express promise. Mere acknowledgement of debt is not sufficient. Next one, definite and unconditional. Okay, promise must be definite and unconditional. You should not put a condition on that. I will pay you on that day. If this happens on that day, it becomes conditional. So it should be definite and conditional. Everyone understood the point up to here? Yeah. Next, after that. So condition can be attached when if that condition is certainly happen, like death. Okay. Any promise that depends on performance or non-performance, happening or non-happening, is not a valid promissory note. Next one. After that, signed. It should be signed by both the parties. Okay, it should be signed by both the parties. Generally, it should be signed by the maker. Lastly, acceptance will be signed by the other person, but mainly maker signature is most important. Okay, next one. Pay money only. Pay money only means what? I have given you 5,000. You should promise me to give back that 5,000. Okay, any promise to pay in kind is not valid. Certain sum you should not tell. I will pay you 5,000 or 6,000. No. 5,000 to 7,000. No. 5,000, 7,000. Certain sum must be there. Okay. Certain person. Okay. You are saying that I will pay to a person. Which person? I will not tell. On that day, whoever. No. Certain person. Maker payee must be certain and definite persons. Okay. And promissory note should contain a revenue stamp. On the revenue stamp, you should give your signature. So promissory note must be on stamp only. Revenue stamp, not stamp paper. Revenue stamp must be there. Okay. It should be duly cancelled by maker signature. Cancel means stamp on that you should sign. Maker should sign. Okay. This is the promissory note concept. 2 minutes 52 seconds. We completed it before the schedule. Next one. Next one. What is the next concept here? Bills of exchange. What is the next concept? Bills of exchange. What we completed now? Promissory note is the concept we completed. Next concept will be bills of exchange. So let's also complete this concept in the same way. Okay, let's begin. For bills of exchange, I am putting a 5 minutes time because it contains some critical aspects. So let us complete bills of exchange in 5 minutes and the time starts now. So what is a bill of exchange? Same concept. Bill of exchange is an instrument in writing, cannot be in oral form, containing unconditional condition attachment. Condition means which kind of condition? Condition which can definitely happen, no problem. Condition which may or may not happen, a problem will come. Okay, I will pay you if it rains on that day, may or may not happen. I will pay if that person die, he will definitely die, no problem. That condition is correct. Okay, unconditional order, because in the bill of exchange, three parties will be there. Number one, the drawee. Number two, the drawer. Number three will be the payee. Okay, listen carefully to the point. Debtor. Okay, debtor is called as a drawee. Drawer is a creditor. Creditor will write a bill. Drawer will write a bill, give to the drawee. Drawee should accept and give back to the drawer. Drawer can either take it and keep it with him till the maturity date, or he can give to some other person. If we give to some other person, that some other person, we call him as a payee. Payee and drawer may be same person, but drawee and drawer can't be the same person. If drawee drawer la confusion comes, that's called as an ambiguous instrument. Okay. So bill of exchange is an instrument in writing, cannot be in oral form. It should contain unconditional order signed by the maker. Who is a maker? Creditor is a maker, also called as a drawer. Okay. Directing certain person, it should be certain person to pay certain sum, money only, to a certain person or to the order or to the bearer. Every other condition is same. Let's see this. Parties, drawer, maker of the bill, drawee, acceptor of the bill, payee, the person to whom money is to be paid. It should be in writing, oral not valid. It is an order. Creditor orders debtor. Drawer orders drawee to pay. Next, unconditional, cannot be having a condition. It should be signed by the maker. Creditor should sign on it. Next, certain sum, 5,000 to 7,000 not valid. Money only, kind not valid. Stamped, it should be cancelled. The signature of the maker should be cancelling the revenue stamp. And parties. Bill of exchange shall contain distinct certain persons, but in some cases, drawer and payee can be same person. Drawer and payee can be same person. Differences between pro note and bill of exchange. This attempt expected question. Nothing different. Definition you need to write first. Okay. Next one. Pro note is a promise to pay. Bill of exchange is an order to pay. Parties. Two parties. Here three parties. Acceptance. Pro note do not require acceptance. Okay. Bills of exchange require acceptance of the drawee. Next, payable to bearer. Promissory note, bearer promissory note not valid, but bearer bills of exchange is valid. That's it. Lesser than the time taken, we completed. I put a time of around 5 minutes now, 2.5 minutes, so we completed. Next concept. So next concept, check. Okay, next concept is check. So check will take a lot of time because with regard to the fast revision only, because there are so many concepts attached to check as well. Okay, let's complete. Check and connected sections. Meaning of a check. Check is a bill of exchange drawn on a specified banker and payable only on demand. There are two types of check. Check in electronic truncated form, check in e-form. So what is the difference between these two things? Okay, let's understand. Sir, first check is a bill of exchange. Sir, what do you mean by that? Like a bill of exchange, here also three parties will be there. Number one, drawer. Number two, drawee. Number three, payee. Okay. In case of a bill of exchange, what will happen? In case of a bill of exchange, what will happen? Bill will have three parties: drawer, creditor, drawee, debtor, payee. Maybe drawer or some other person also can be there. Correct or not? So, is the point in case of a bill of exchange. Check also have three persons. Number one, drawer. The person who signs the check is the drawer. Debtor will sign the check. Okay. And give it to the bank. Bank becomes the drawee. That's why bank is called as a drawee bank. Okay. Payee will be the creditor. Okay. Payee will be the creditor. So debtor will draft a check. He will sign the check and give to creditor. Creditor can put it to the endorsement and transfer to any number of people. No problem. Okay. So a check is a bill of exchange drawn on a specified banker. So drawee is a bank here. Payable on demand. Sir, what do you mean payable on demand? I gave you a check. You folded it, kept in your pocket and forgot. Payment is not done. That's your mistake. Because you are not putting that check to presentment to the bank. Okay. You should first put that check into circulation with the bank, present it to the bank, demand the bank pay to my account. If not paid, then the mistake is with the bank. Mistake is with the bank. Bank has no personal grudge on you. Why it will not pay you? If funds are not there in the account of that other party, then bank will send him a notice. That's what we are going to see in the dishonor of a check. Okay. There are two types of check. Check in truncated form, electronic check. Check in truncated form, electronic check. Okay. Next. So essential characters of a check. Check is a bill of exchange. So it will have all the essentials of a bill. Drawn on a special bank, also called as a drawee bank. Payable only on demand. It should be payable whenever holder present it for payment. Next. Parties to a negotiable instrument. Parties to a negotiable instrument. Drawer. Person draws the check. Okay. Person who draws the check is the drawer. In a check I am talking. Parties to the negotiable instrument called as a check. To the check there are three parties. First party, drawer. Who is this fellow? Person who draws the check. He is a debtor. He has a liability which is a primary liability. Primary liability means I purchased goods from you on credit. I purchased goods from you. Okay, I have a liability to pay you. If I give a check, now banker is having liability to pay you. That's why banker liability is not a first liability. First liability debtor. Secondary liability is with the banker. So person who draws the check is a drawer. He is a debtor. Liability is a primary liability and conditional. Okay, next. Next party, drawee. Person to on whom check is drawn. It is a bank who makes the payment. Payee, person who is named in the negotiable instrument. Person to whom the payment is made. Is to be made. Very important document this is. Okay. Check truncation form, also called as a clearing process. Check clearing process. I don't wanted to discuss this now and waste your time. Okay. First, listen carefully. Why I am putting this is there are two important definitions. One among these will come in J25 examination, 90% chance. One among them will come. Both can also come. If it comes, you should be able to write as it is. So remember, truncated check means what? Truncated check means a check which is truncated, means electronically converted, truncated during the clearing cycle. Don't ask for doubts now. This is not the time. Class of 1.5 hours I spent on clearing these concepts. Now this is not the time to understand, time to remember. That's it. Okay. Sir, I did not take your classes, sir. I slept when you teach this concept. Then what to do? Then read and remember. Truncated check is a check which is truncated during the clearing cycle. During the clearing cycle, either by the clearing house or by the receiving or a paying bank. Okay. Simply to tell, physical check kept in a machine, this machine will convert the physical check into electronic form, transmit to the other end. That's it. Beyond this, don't ask me. This is not the time. So, truncated check means a check which is a truncated, means converted physical into electronic form during the clearing cycle, either by a clearing house. If clearing house is not there in that city, then the receiving bank only will do that. How it will be done? By generating a electronic image of the check. By generating electronic image of the check. And physical check you need not again give. Will substitute physical movement of the check. Next, electronic check. Truncated check la physical will be given, kept in a machine, convert into electronic image. Electronic check na, sir, check itself is an electronic. Net banking, NEFT, RTGS comes under that category. Okay. Electronic check means a check drawn in electronic form using a computer resource. Computer resource means either mobile phone or system, anything. So first one, electronic check means a check. It is a check. Truncated check means a check. It is a check. Drawn in electronic form means from the beginning itself it will be drawn in electronic form using a computer resource. Very good. Okay, using a computer system. Next, that will have complete security. OTPs, everything will come signed in a secure system using digital signature and asymmetric crypto system. Asymmetric crypto system. Asymmetric means random. OTP will come. Okay, for example, first time 6412 came. Next time what will come? Some 8939 will come. What is this link between the previous OTP and this OTP? There is no link. That's called as a asymmetric. There is no link between one and another. Random. Crypto means what? Language is converted. So in a cryptic language they will tell. So more about this, don't ask me now. This is not the time. Remember again, two definitions to both or one can come in the next attempt. Means in another 2 days you will definitely find one question from this. As far as I am concerned, there is no wrong in learning things now. Tell me, what is a truncated check? Truncated check means a check which is truncated during the clearing cycle, either by the clearing house or by the receiving bank or a paying bank, any bank. Okay, by generating an electronic image of the physical check and will substitute the physical movement of the physical check. Electronic check means a check which is drawn itself in electronic form using computer resource, using a secure system and using a digital signature and asymmetric crypto system. Over. Next. Sections connected to check. 72, 73, 74. Okay. Let us start. Presentment of a check to charge the drawer. To charge the drawer. Drawer is a debtor here in the check. Bill drawer is a creditor. Here drawer is a debtor. Okay. Presentment of a check to charge the drawer. Charge means what? To make him liable. To make drawer liable. Okay. What I said, check is payable on demand. I am a drawer. Okay, I am a debtor. I gave a check to creditor. Creditor kept the check kept in almara and he forgot. Due date payment not paid. Then he sued me in the court. Kaushik did not pay. Are Muttal, I paid you. Okay, the moment I gave the check itself means you can present in the bank. So, whenever you wanted to charge the drawer, being a debtor of a check, okay, see, a check in order to charge a drawer must be presented to the bank. That's why check is payable on demand. Okay, before what time you need to, before he closes his account in that bank you please put the check for circulation. That's why before the relation between bank and drawer is altered. Next, sir, I wanted to make some other person liable. Whom liable? Some other person liable. Don't ask other questions now. Why some other person? This is not the time. Just remember, if you wanted to make drawer liable, present it before his relationship end with that bank. If you wanted to charge some other persons also on the bill, on the check, then a check in order to charge any other person except the drawer. Other persons, if you wanted to charge, it should be presented within reasonable time. Reasonable time. Here, before the relationship end. Next, presentment of instrument payable on demand. Presentment of instrument payable on demand. A negotiable instrument is payable on demand shall be presented within reasonable time. Next, dishonor of a check. The most important question. Dishonor, most important. Okay. What is dishonor? Dishonor means you gave me a check, I presented it bank. Bank has resent me saying that funds are not available. That's called as a dishonor situation. Dishonor is also called as a bouncing of check. Means I gave check, it bounced back again. Bank has returned back and said that there are no funds. Take a new check. Okay. See here. Dishonor of a check due to insufficiency of funds in the account of the drawer is the question. Let us understand. When section gets attracted, see here. Condition 1. A check is that there are totally 6 conditions. If all the 6 conditions are satisfied, then dishonor ki drawer will be punishable. Simply to tell I am a debtor, you are a creditor. Okay, I gave a check, but the check was bounced. Now I will be punished or not? No, I will not be punished just like that. You should satisfy 6 conditions. Then only the debtor will become liable and you can punish a debtor. Okay, what are the conditions? Let us see. Check is drawn by a person on account maintained by him with the bank. So first one, he should give a check belonging to him, not belonging to his wife, children, etc. Next, check is given for payment of money. Payment of money. Sir, what is check is given for payment of money? Check should not be given as a guarantee or a security. It should be given for real payment. Next, check is given to another person to pay to his account. Okay, sir, another account means to my account I will give check. Yes, there is a concept called as a self check. Do you know what is a self check? I have an account with bank. Okay, if I go to a ATM center and withdraw 50,000 only will come per a day. No, I want 4.5 lakh rupee. How to get 4.5 lakh? Self check you have to give. Self check means you will issue check on your own bank account. Okay, then banker said fund is not there. Then bouncing will not apply because you are not drawing check on some other person. You are drawing a check on yourself. So check is given to another person to pay to his account. 3 conditions. Drawn by a person on an account maintained by him with the bank. Second one, check is given for payment of money. It should be given to another person after writing the check. Okay, and check is given to discharge any debt or a liability. Very, 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 very important point. Do you know what it is? For example, A is there, B is there. A is a friend to B. Yes, A qualified CA. Now A said to B, Array B, if you qualify CA in the next attempt, I will give you 1 lakh rupee. He qualified. He gave 1 lakh rupee check to him. He presented, bounced back. He wanted to sue him. No, because gift key, if you give, gift is not a debt or a liability. Listen, reverse. A purchased goods from, sorry, A sold goods to B. Okay, A sold goods to B. B has to pay. B gave a check, bounced back. Now I can punish because there is a debt or liability to him. Next, 5th one. Check is returned as unpaid. Means another condition. You gave the check and it is returned back again. It is returned back again as paid or unpaid or unpaid. Due to what? Due to insufficiency of funds, not due to other problems in the bank account. Due to insufficiency of the funds in the bank account, it got bounced back. So let's understand. See here. Check is drawn by a person on a bank account maintained by him with that bank for a payment purpose and to another person. And it is not a gift, it is a debt or a liability. And it is returned as unpaid and due to insufficiency of fund. Okay? No. Next one. If all these 6 conditions are satisfied, punishment for dishonor. What is the punishment? Imprisonment up to 2 years or fine up to 2 times the amount on the check or sometimes even both. Remember the punishment, he will ask for 1 mark. Next. When section 138 punishment will apply. So when you can punish if some conditions are satisfied. Check is presented for payment within the time period. Okay, see here. So to punish a person, first to attract dishonor, 6 conditions. To punish him, again 3 conditions are there. Check is presented for payment within a time period. Means you should present the check within time period. What time period? Within 3 months or other validity period, whichever is earlier. Whichever is earlier. Next. Once a check is given to the bank said funds are not there, it will return back the check. It will return back the check. So bank will inform the holder or the payee. Okay, means I gave you are a debtor, I am a creditor. Okay, you gave me a check, I presented to the bank. Bank again will give back the check to me and say, I am very sorry, sir. This check can't be presented because the funds are not there. Okay, bank inform the payee about dishonor. I'm the holder now. To me, it will tell. Holder gave a notice to the drawer, means a debtor. Simply, now creditor will give a notice to the debtor. Alright, debtor, make the funds available. Make the funds available within 30 days. So, notice to the debtor to make the payment and it is given within 30 days of receipt. Receipt of information from the bank. First, check should be presented within 3 months or other validity period, whichever is earlier. Bank will inform the holder that the funds are insufficient and holder should give a notice to the debtor to make the payment, and that notice should be given within a period of 30 days. Okay, and payment is not made in the next 15 days. If all these conditions are satisfied, then the punishment will be there. Okay, next one. Dishonor connected provisions. Presumption in favor of the holder. Presumption in favor of the holder. General presumption of the court. Let us read first. Court will presume in case of dishonor of a check that holder received check as per the terms of section 138 for a discharge of debt or liability. Debt or liability. This is purely a rebuttable presumption where drawer may prove to the contrary. Read it first. Pause the video and read it. Pause the video and read it. Okay, read the point? See here. Presumption means assumption, deem. Court will assume. Okay, court will assume. In case of dishonor of a check, whenever check is dishonored, court will believe that. For example, I am A, you are B. I gave a check to you. As a gift. I gave a check to you as a gift. You presented, but not presented because of insufficiency. Check was dishonored. You will file a case against me. Court will start the arguments with a belief that this check was given for some debt or liability, not for gift. Now, who should prove that it is a gift? Drawer may prove to the contrary. So, court will start its arguments. Court will start with a belief that the check was given for a debt or a liability, and it will try to punish the drawer only. Drawer should prove that it is not given for a debt or liability, but it is contrary, means different. Okay, who should prove? Drawer has to prove. Number 2, no defense in certain cases. Let's read. It shall not be a defense in prosecution of offense under section 138 by the drawer that he hasn't believed that check will be dishonored on its presentment for the reasons mentioned in that section. Sir, I didn't understand. Read it once. Again, pause the video and read. I'll explain. Okay, listen. I am a drawer. I gave a check to you. I'm a drawer, debtor. In a check, drawer is a debtor. I gave a check to you on a particular bank. You presented it for payment. Payment not made because of insufficiency of fund. Check was dishonored. Check was dishonored. Dishonored because of insufficiency of funds. Game over. Owner, and now listen carefully. Matter went to the court. Drawer, being the debtor, said to the court that, sir, I don't know that there is an act called as negotiable instrument. Under that act, there is a section called as 138. As per that 138, when the check was given, funds must be there. If funds are not there, dishonor. If dishonor, court, I have to go. I don't know about all these things, sir. If I would have known that, seriously, I would have given the check. I thought, that's why I gave a normal check, sir. So please, sir, I don't know anything about law. Okay, auntie promise, uncle promise. Like this, you should not do the overacting in the court. Okay, there shall not be a defense in the prosecution, means court proceeding of an offense under 138 by the drawer, means a drawer cannot take a defense that he has not believed that, okay, check will be dishonored on its presentment for the reasons mentioned in that section. Means, oh, debtor liability ki check once given, it should not be dishonored. I don't know, sir. That's why Contract Act one point is there. Ignorance of law is no excuse. Next, mark it important, Jan 25. Study material, one question is also there on this, please do. And don't forget, study material book back, some questions are there, 7-8 questions. Don't forget to do those questions. They will give lot of clarity. And last attempt question paper and answers you see, suggested answers. With regard to Negotiable Instruments Act, super questions came. And recent attempt MTP, RTP also you check. That's it. Over. Done. You will definitely crack that 15 marks in exam. What you have to do? Study material book back questions. Okay? 10 minutes time. Last attempt question paper. With regard to this, read the question and answer. Another work done. And third very, very important thing, this attempt MTPs relating to negotiable chapter and this attempt RTP relating to negotiable chapter. All this you have to complete in 1 hour after this revision. That's it. 2 hours. 45 minutes to 1 hour my work. Remaining time your work. You will get the 15 marks. 15 marks is a savior for law. Let's start. Rules for compensation. Mark it important for J25 again. I will mark 8 questions. 4 questions already completed. This is the 4th question. Okay. Rules for compensation. Sir, what is rules for compensation? Whenever you gave me a check, you gave a check to me. Okay. What I believed, okay, you will give me a check, I will put it in the bank, I will get the money, I will pay to some other person once I get money. If you dishonor to me, I will dishonor to him. For that, there is a lot of risk I am taking. Therefore, I will ask compensation from you. How it will be? J25, very, very important area. Okay. Let's see. When section gets attracted, section 117 gets attracted in case of dishonor of a check, promissory note, or a bill of exchange. Anything, any negotiable. What if section gets attracted? Person liable to make the payment shall pay compensation. In case of a promissory note, bill of exchange, debtors has to pay compensation as per the rules. What is the rules? Very, very important content. Okay. See, as a holder. Okay. Holder is entitled to recover the amount due along with expenses incurred for presentment, noting, and protesting. Okay. So holder means the person to whom it is paid. For example, I'm a creditor. What are the rights of a creditor? How much compensation you have to pay to the creditor? Creditor, the holder, is entitled to recover the amount due along with expenses incurred for presentment. Okay, he's a travel expenses, everything. Noting and protesting. There is one concept for bill of exchange called as a noting and protesting. Noting, protesting applicable for bill only. For a bill. Next, if holder and the person charged are not in the same place, if holder and the person charged are not in same place, payment shall be made as per is not in the same place. Means they are in 2 different countries. Then the payment shall be made as per current exchange rate. Current exchange rate. Read the topic once. Dishonor of a check, promissory note, bill of exchange. Very good. Next, person liable to make the payment. In case of a bill, drawee. In case of a check, drawer. In case of a promissory note, the person who draws it, drawer again. So that person who is entitled to make the payment, he has to pay compensation as per the rules. What are the rules? So holder, the person who hold it, is entitled to recover the amount due along with expenses incurred for presentment. Next, If the holder and the person charge, if the payer and recipient both are in two different places, payment should be made as per the current exchange rate. This question can come in J25. This question is expected. In this, they can ask on this exchange rate point. Current exchange rate, what is going on between those two countries? At that exchange rate, you have to. Next, as an endorser, okay. Endorser shall first pay the endorsee the amount due and then recover the amount from the person liable with interest at the rate of 18% for a period between payment made to him will realization received. Till realization is received. Sir, I didn't understand this. 1 minute time. Read it properly. I am pausing it. Okay. Hope you read it. I will explain you. A gave check to B. I am explaining from a check point of view. A gave check to B. Okay. B gave check to C. Now B is a endorser. B gave check to C. C is a endorsee. C took a check, came to the bank, dishonored. C ki B is only known. C don't know who is A. So C will sue B. B will pay. B is a endorser. Endorser will first pay to endorsee. B will pay to C. Over. Now B will recover the entire amount from A, not only the amount paid, along with the interest. So endorser shall pay to the endorsee the amount due and then recover amount from the person liable along with interest at the rate of 18% per annum for the period between that particular date. Okay. Actually, on what date you should pay? Actually, on what date you actually paid. Between this, I will ask interest also. So, if you are only a holder, not being an endorsee, not being an endorser, then what will happen? Only amount due with expenses incurred. Here, amount due, expenses incurred, along with interest. Next, both are not in same place, same. Next, drawing a new bill. Important point again. The person entitled to compensation from the person liable may draw a new bill on him to recover the amount due along with expenses. Such bill shall be accompanied with dishonored bill. If this bill is dishonored, same rule shall again apply. Means you have to pay me amount. You have to pay me amount. Along with what? For example, I gave you a bill. I gave you a bill. Bill worth 1 lakh. You did not pay. 18% interest is charged on that. It became 1,18,000. Now on that 1,18,000, I will write another bill. You will accept and give me back. At least pay that properly. If you pay 1,18,000 properly, now first bill of 1 lakh will be cancelled automatically. If you don't pay that, this both you didn't pay. Again, same rules will apply. On that 1,18,000, again 18% per annum, interest will get attracted if you are an endorser. Clear? Mark this, very, very important. They can ask. On this one, study material question is also there. Please don't fail to do. This is only just a differences. You can read it later. Next, types of instrument. From this one question will come in this attempt. 99% chance is there. 6 instruments are there. From that 6, 1 can come. Okay. Bearer instrument. Bearer instrument is an instrument in which name of the payee bank. Name of the payee is specified along with the words or bearer. And the last endorsement is blank. And negotiated by mere delivery. Sir, what is this? See here. Bearer instrument is an instrument in which name of the payee is blank. Name of the payee is blank. What do you mean by name of the payee is blank? To whom you are going to pay, that name will not be there. Simply, shall I tell you one thing? Bearer instrument means sign is not required. What is not required here? Sign is not required. Whoever hold it automatically will become owner. Okay. You need not mention who is the payee. If you hold it, you will become the owner. Next, name of the payee is specified. Either name of the payee should be blank or clearly you should write. Okay. Name of the payee, Mr. A or bearer. Means what? Either A or any other person. Any other person means it again became bearer. Or originally it was given as a pay to A. Endorsement timeline, it was converted into bearer. Last endorsement is blank. Beyond this, I wanted to discuss today. Just remember, question comes in exam, na? Write down these 3. Bearer instrument is an instrument in which name of payee is blank or name of the payee is specified along with the words or bearer. Pay to or Kaushik Mukesh or bearer. Means what? Name of the payee is specified along with the words or bearer. Next, last endorsement is blank. Endorsement or endorsement both is same. Last and originally it is a order instrument. Later one person has changed it during endorsement time to order. From then it will become a bearer instrument. Negotiated by mere delivery. Next, order instrument. What instrument here? Order. Order instrument means clearly you will write pay to R Kaushik Mukesh or to his order. Means what? First pay to him. If Kaushik Mukesh orders to pay to some other person by endorsement, pay to him. That's it. Name of the payee is entered. Okay. Next, amount payable in order to such person. Amount is payable to order of such person. Okay. Or either this or this or this. Name of the payee is entered. Payee name you entered. Or you said either payable to the order of such person. Okay. If payee says to pay some person, I will pay to him. Or originally it was a bearer instrument. Later they filled the name and completed it. Last endorsement is full. Negotiated by endorsement and delivery. Signing is required. Next. Inland instrument within India. That's the inland instrument. A pronote or a bill of exchange or a check shall be drawn or made in India. And so pronote, bill of exchange or a check drawn or made in India and payable in India or payable to a person resident in India. Payable in India or payable to a person resident in India. Means what? Payable in India. If you pay in India, you may pay to resident or you may pay to non-resident. If you are paying to a person resident in India, place where you are paying is irrelevant, whether you may pay in India or outside India. So, person is irrelevant if you are paying in India. Place is irrelevant, you are paying to a person in India. In both the cases, it will become inland instrument. Okay. Any instrument other than inland instrument shall become foreign instrument. Shall become a foreign instrument. Special concept in case of foreign instrument. Liability of the maker or acceptor. Liability of the maker as per the law of place where promissory note, bill of exchange or a check is made or drawn. Liability of the acceptor or endorser as per the law of place where it is made payable. This concept please read properly. 1 minute time again. Okay. See here. Special concept on foreign instrument. Liability of the maker, liability of the acceptor. Okay. Liability of the maker. Liability of the maker. As per the law of the place where promissory note or bill of exchange or check is made or drawn. Okay. If the check is drawn in India, as per that law, everything will work. Punishments and everything will be working. Liability of the acceptor. Liability of the acceptor. Sir, why acceptor will be liable? In case of a bill of exchange, drawee will accept. Liability of an acceptor. As per the law of the place where it is made payable. As per that law, punishments will be there. Sir, I did not understand this. There is one illustration given in the study material with regard to 134. Read that for 4-5 times. Same thing I have given in the form of a diagram here. You read it and complete. Next. Concept of holder and holder in due course. This is not there in the study material, but questions are coming on this. Listen carefully. Who is a holder? Holder is a person who is entitled to a promissory note, bill of exchange or a check. Okay. Therefore, he is a person who is having a right to hold the instrument. Entitled means right. Okay. Right to hold means what? You have to pay me some amount. You gave me a check. I have a right to hold it. Okay. If he is a holder for value, he will have right to recover the amount specified. Okay. So first, to become a holder, what should be there? First, you should be entitled. You should have a right to hold that thing. Means if you steal from some person, you have no entitlement. So you are not a holder. A thief who made a theft of, who stealed this particular bill of exchange or a check, promissory note, will never become a holder because for you he did not give the check. Okay. Next, he has a right to hold the instrument. He had a right to hold the instrument. Then you will become a holder. In that, you are having some amount payable, amount receivable to you. Then you are called as a holder for value. Now you can recover the amount also. Not just having a right to hold, you can also recover amount. Sir, if I hold, I will definitely have a right to recover amount. Shall I tell you one thing? I am a creditor. I sold goods to you. I sold goods to you. I sold goods to you on credit. You gave me a check. You gave me a check. Okay, you gave me a check. Now tell me who I am. I am a holder. I am a holder. I am a holder. Reverse. Bill of exchange. I am a creditor. I sold goods to you. I wrote a bill of exchange to you. I wrote a bill of exchange. I gave to you. You accepted. You accepted. I sent my agent to you. You are in Chennai. I am in Hyderabad. I sent my agent to you. Okay, my agent took the bill. After you accepted, you return accepted and give it to him. He is a holder now, but he is not a holder for value, because he has a right to, he is entitled to get that bill because I gave him a power as an agent, but he has no right to recover amount because amount is recoverable by me, not by him. So he is only a holder, not a holder for value. So like this complicated questions will come. So agent is a holder, but not a holder for value. So holder is a person who is entitled to hold promissory note, bill of exchange, or a check. Okay. Next, holder for value means he has a right to recover also. So he is a holder plus a recovery person. Holder in due course. Very, very important concept here. Holder in due course means a person who obtains the possession of any instrument for a valuable consideration. Means some consideration is there. He will have title on the bill and obtained in good faith before maturity date. Before maturity date. Simply, 5 essentials are required to become a holder in due course. First, he must have possession. Yes, he is holding. He is having a valid title. Yes, he is having a right. No theft. Really, he is a person. Received it for valuable and lawful consideration. Means what? Some debt is there. For that, you gave me the bill. I am a creditor. I wrote a bill. I wrote a bill. See, I can explain this way. A, B. B gave a bill to A. A accepted and give to B. B gave to C. C is the holder in due course. Why? He is having the possession. Number one, he is having a right to hold it. He is having a right to hold it. Title. Because B has to pay to C. So liability is there to C. So C has a right to recover. Title. Next one, consideration. 1 lakh rupees is there. Next, obtained in good faith. Good faith means what? He don't know about the past. Okay. Holder in due course is a practical person. What happened in your life in the past, I don't care. You do whatever you want in your past. Okay. Once you give me, are you correct or not, I will see it. Corrected? What you done in your past, I really don't care. Okay. I will hold you in good faith. Good faith means what? You are clean in the past. Okay. No, I am not clean in the past. I am a very bad person in the past. I don't care. I am a holder in due course. I am a very positive person, broad-minded person. Holder in due course also like that only. B made theft of a bill from some other person. I don't know. B has to pay me. He gave me the bill. Good faith. I don't know what happened in the past. So good faith is required. Next, and he should obtain it before maturity. Before maturity. If all these 5 conditions are satisfied, then a person will be called as a holder in due course. Next, inchoate instrument. What instrument? Inchoate instrument. Sir, in these two, one question can come in exam. Please be very, very careful. Inchoate instrument. Inchoate instrument means a blank instrument. Which instrument? Blank instrument. Or incomplete in certain important aspects. So it is an instrument which is blank, either completely or incomplete in certain aspects. Amount I will put blank. Signature blank and not valid. Essentials it should not be. Other things you can put it blank. Nature. The drawer or maker or acceptor or endorser signs and delivers a negotiable instrument to the holder, either by putting fully blank or by writing in the negotiable instrument as incomplete. Rights of the holder. Rights of the holder for value can recover only up to the amount intended to be paid. Right of a holder in due course. He can recover amount. He can recover any amount, but not in excess of the value covered by the stamp affixed. Read it properly. 1 minute time. Read it first. Okay. So see, inchoate instrument means it is an instrument in which is blank or incomplete in certain aspects. Okay. Next, the drawer, maker or acceptor or endorser. Drawer of a bill. Okay. The drawer of a bill or a promissory note, maker or acceptor or endorser, anyone. Okay. Signs and delivers a negotiable instrument to a holder. Signs and deliver. Signing is mandatory. Okay. Deliver negotiable instrument to a holder, either by making it fully blank, signature made, remaining things are blank, or writing on the negotiable instrument itself as incomplete. Okay, that's called as an inchoate instrument. Mug up this, literally mug up, read 10 times and remember. At least till exams. Immediately in exam, puke it, complete it. But remember, it will come in exam. Which one? Inchoate instrument. Okay. Next, it is an instrument which is blank, either or incomplete in certain aspects, or the drawer or a maker or acceptor or endorser signs and delivers the negotiable instrument, either putting it fully blank or writing there incomplete clearly. Okay, right of a holder. Listen carefully. Remember and mark up. Holders are of two types: holder for value, holder in due course. Holder for value, he can recover only up to the amount to which he is intended to be paid. For example, you have to pay me 1 lakh. You have to pay me 1 lakh. Okay, I have written 5 lakhs there. I cannot recover 5 lakh. You have to pay me only 1 lakh. Na? That 1 lakh I can recover. But if it is a holder in due course, he can recover beyond 1 lakh, but not beyond the stamp value. Whenever you take a revenue stamp and affix on a bill, etc., on that revenue stamp value will be there. 5 lakh revenue stamp, 3 lakh revenue stamp. You can collect more than 1 lakh, but not more than revenue stamp amount. Next, ambiguous instrument. Ambiguous instrument means such an instrument which is created because of faulty drafting. Faulty drafting means there is a confusion whether this is a bill of exchange or a promissory note. Okay, it is an instrument which can be construed either as a bill of exchange or a promissory note. Don't ask extra questions, it takes time. The holder may, that means the person who hold it should decide first whether to treat it as a bill of exchange or as a promissory note. If we treat it as a bill of exchange, that's final. If we treat it as a promissory note, that's final. But once it is construed, it cannot be changed later. Just read and remember. Next, negotiation types. Negotiation types. What is negotiation? Delivery. Giving it to from one person to another. Basics. One of the essential character of negotiable instrument is negotiation. Negotiation means a free transfer of negotiable instrument from one person to another. Importance of negotiation. Ownership will be transferred. When negotiation is complete, negotiable instrument is transferred to another person with a view to make a person as holder. Okay? Means you are transferring the bill or check to some other person to make him a holder. To make him a holder. That's called as a negotiation. Means if a person steals your check, then you don't have intention to deliver to him, negotiation is not completed. So negotiation is completed only if you hand over the document to another person with an intention to make him a holder. Next, kinds of delivery. Actual delivery, constructive delivery. Means what? Actual delivery means what? Actual delivery means directly you will give it. Okay, directly you will give it. I will give. I am a creditor, I will give bill to you. I am a debtor, I will give check to you. Actual delivery. Constructive delivery means I will not give directly. Okay. Constructive delivery, two things: proper, improper. Proper, giving it to agent, clerk, etc. Giving a piece or half of a negotiable instrument as a token of full document. As a token of full document. Listen carefully. Bill of exchange you have to give means a full bill you have to give. Cutting a piece, giving it to a person will not make. This exam question. Examiner, do you know what question came? A person has written a bill. Okay. He torn one piece of a bill and he gave counterfoil to another person. Is it a negotiation? No. Giving a piece or half of a negotiable instrument as a token of full document can never become proper negotiation. Okay. Means you should give full document to the agent or servant, etc. Next, negotiation types. Okay, mere delivery or endorsement and delivery. Miscellaneous. Endorsing a bill in favor of another. Endorsing a bill in favor of another, but failed to deliver, do not constitute a valid endorsement. Okay, means I have written the name of a person, but I did not give him. Delivery not completed means presentment is not completed, negotiation not completed. Motive of negotiation must be to transfer ownership. See here, important. Upon endorsement, if the endorser die before it is being delivered to the endorsee, legal representative of the deceased cannot negotiate by mere delivery. On this one, study material question is also there. Means negotiation topic, you go into study material. In the study material, in the topic, one example was given. Read that example. One paragraph will be there. In that paragraph, one example they have given on this. Read this and do that example. Full clarity. Next. Situations when presentment is not necessary. Means what? You need not present the check or a bill to the bank itself. Presentment, or for example, promissory note. I am a debtor. I gave a promissory note to you. On the due date, you should come to me and present to me. Then only I will make the payment. But presentment is not required in 3 cases. What are the 3? Important, J25 again. Presentment is not required. An instrument will be dishonored. Presentment is not required. An instrument is dishonored in these cases. Let's see. Maker or drawee or acceptor has intentionally prevented the presentation. Means they intentionally prevented it. Who? Maker of a promissory note, drawee to a bill of exchange, or acceptor, drawee or acceptor, has intentionally prevented the presentation. Okay. Next. instrument is payable at his usual place of business. Means bill of exchange I gave to you, you accepted and gave me. You said, sir, please come to Hyderabad, I will pay. I came to Hyderabad because it is your usual place of business, but you close that premises, doors are closed, shutter closed during business hours, during usual business days. Normal, no festival, no Sunday, nothing. Normal working day. During business hours, I came. You closed it. And you said me, come on that day. You said, please come to me on 21st August. No Sunday, it's Wednesday. It's Wednesday. And I came at 11:30 a.m. in the morning. Peak business hour time. You close the shutters. Presentment is not required. Automatically, it will be dishonored. Next, instrument is made payable at a specified place. Okay, you said come to that specified place, not my place of business, some specified place, and neither he nor his authorized persons are available to make the payment. You said please come to Chennai, I came, you are not there. Then where the person can't be found even on a reasonable search. Okay, next, I tried my level best, but you are not found. In that case, presentment is not required and instrument will be dishonored. To present, you should be available na. First case you are preventing yourself. Second case you are closing the shutters, not available, and I can't find you where you are located. All these things, presentment is not required. Next, presentment of any negotiable instrument is not required if the person is engaged or decided to pay notwithstanding any presentment. See, this is very important. I am a drawer. I wrote a bill of exchange. You are a drawee. I gave. You accepted and gave me back. You said, sir, on the due date, you need not come to me. I will only come to you and pay. You only said in writing. So, is not required if the person decided to pay notwithstanding presentment. Means notwithstanding means ignoring. You need not come to me and present. I will only come to you and pay on that day. Then presentment is not required. Next, upon the knowledge of non-presentment, the party charged with. Okay, so see here. Upon the knowledge of non-presentment, he did not present. The party charged with may make the payment partly, or agree or promises to pay either wholly or in part, or the holder has waived the right to take the advantage of default. Means when presentment is not required, it was not presented. Okay, it was not presented, and the party charged with means the party liable. Who is the party liable? In a bill, drawee is liable. The drawee made a payment partly. Means you need not present, sir. I will only pay, but I can pay only partly. Remaining I will pay later. Okay, or agree to pay either wholly or in part. He said, sir, today I can't pay anyway. I will pay after some number of days. Then you need not present, because even if you present, I can't pay anything today. I agreed to pay. Next, holder said, sir, you are my friend, na? No problem, I am waiving it. You pay whenever you want. Then also presentment is not required. If the banker commits any delay, then banker also will become liable and he has to compensate the holder for such loss. Okay, because banker is a drawee, secondary liability is there. Okay, with this, we completed the entire Negotiable Instruments Act, a super quick revision, 1 hour, 15 marks. Okay, so prepare well for your examinations, all the very best. Okay, you are a champion. Don't forget, keep faith, keep hope, leave the rest to the God. He will take care. Okay, so don't take extreme pressure of learning. Okay, feel free, keep your mind clean and safe, prepare well for your exams. All the very best. Love you all.